This is not an expert witness subpoena. Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we've been going through all of the documents in the Idaho 4 case, and I didn't do a video yesterday, even though we had a bunch of stuff drop, because it was literally just orders sealing all of the exhibits and all of the responses. None of it had any information. We not only have the subpoena Duces Tecum, which is them trying to get an expert witness to come and testify. I believe we have a personal, normal person witness one too, and I'm about to tell you why. Now, here's everything that's posted over the past few days. As you can see, it's just orders sealing state's objection, orders sealing exhibits to state's objection, orders sealing exhibits, just everything being sealed up. Now, the first thing that we're going to actually go over is the state's objection to the defendant's motion to compel for the sanctions. It says relevant facts. Let's see what the state has to say for itself. The state has been actively engaged in replying to the defendant's request for discovery, including materials related to potential expert witnesses, since the original discovery request was filed on January 10th of 2023. As ICR 16J contemplates, discovery involves a continuous duty to disclose, meaning whatever you find, whenever you find it, you got to send it over, you got to tell them about it, which the state has and will continue to comply with what? Everything that you've attempted to send over, there's nothing there. There's no reports. There's no analysis. There's no opinions. You don't even have, you haven't had anything this whole time, state. Quit playing. We've seen it happen with conversations in almost every single hearing where you've been asked for something and you don't have it because you didn't do any of the work. So how could you produce something that you never had to begin with? This specific continuing duty to disclose evidence that ICR 16 compliance is not a one-time event. Defendant currently notes this case involves a substantial amount of discovery. Defendant cites over 68 terabytes, and the state does not dispute this. The discovery received by the state from multiple agencies has been provided to defense in the same manner it was provided to the state, meaning as discombobulatingly unorganized as we were given it, we didn't bother for the sake of our own case and for the sake of knowing exactly what we're actually going to be talking about whenever it comes to court. We didn't organize it. We didn't actually sift through it for boo-boo and what's actually necessary or not. However stupidly unorganized we got it, we just passed it on to them the same way. Yeah, we've known that from the beginning. The state is in the same position as the defendant in this regard. That is pathetic. Pathetic. Footnote. Defendant complains and appears to represent that he has not been provided with adequate information from the state. This is patently untrue. By way of example, to appreciate the true degree of analysis and use by the defendant of discovery that has been provided, the court need look no further than the extensive detail in the defendant's motion for a Franks hearing, the 20-plus supplemental discovery request and related materials, and the many other detailed substantive motions he has filed. So because the defendant's Franks motion is detailed, that proves that the state has been handing over discovery. And isn't the fact that there's 20 plus supplemental discovery requests kind of like proof that you haven't actually turned over anything? I'm confused about their argument there. The court will reflect that the state has provided extremely detailed responses to defendants' requests for discovery and motions to compel above and beyond what is required by Rule 16. On December 18th of 2024, the state, in compliance with the court's order, filed its guilt phase experts consistent with ICR 16b7. These disclosures were filed 7 months and 24 days before the commencement of trial. As of the date of this filing, we are 7 months and 12 days before the commencement of trial. Nevertheless, defendant argues that he has been prejudiced and requests sanctions. Defendant's arguments are without merit. How? You're not handing them anything. She's being very clear. Ann Taylor is being very clear in her motions, however she can for the gag order, exactly what's missing. There's nothing being handed over to the defense when it comes to whatever they found discovery and evidence-wise on 67 devices and other things. And there's no reports, analysis, or opinions for any of the DNA stuff. So how are you complying? Argument. The state has complied with the court's order in Idaho Criminal Rule 16b7 regarding disclosure of expert witnesses. No, it really hasn't. On December 18, 2024, the state filed state's supplemental response to requests for discovery regarding expert testimony in compliance with the court's unredacted sealed order governing further criminal proceedings and notice of trial setting, order on October 9, 2024. That order stated as follows under Section C, Discovery and Expert Disclosures. Experts. A list of experts the parties intend to call at trial, including a copy of the expert's report consistent with ICR 16b7 and a copy of the expert's curriculum vitae. I always just say credentials because I feel like I can never actually say that word right. Shall be disclosed to the opposing party as follows. State's guilt phase experts, December 18th, 2024. Okay, but there was 25 on that list and only 5 of them actually had anything attached to them when it comes to what they're going to actually present. You can't have 25 people coming and talking and only 5 people presenting to the defense what's going to be talked about. Page 2. The order refers to ICR 16b7, which states in relevant part, expert witnesses. On written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 03, or 05 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data of those opinions, and the witness's qualifications. Okay, and what did the defense state? That those opinions were not there. That qualifications and stuff were there, I guess. But when it comes to opinions and analysis, none of that was there for the most important parts, i.e. the devices proving a connection or not, which we've already been told there is none, and there was no social media stalking or any targeting or stalking at all when it comes to Bryan, according to the prosecution, and the DNA. There's no DNA information being handed over to the defense. They go on to talk about the same case that the defense talked about in their argument for this, which is State versus Morin. The state talks about a bunch of cases right here. I'm not going to read them on camera, but as usual and as always, the description box will have the links for all of these documents. It goes to state. Turning to the case at hand, on December 18th, 2024, the state disclosed 25 potential experts the state intends to call at trial. Why are they potential? In an abundance of caution, the state included witnesses that the state does not label as technically experts within the meaning of ICR 16b7, but anticipates that the defendant might disagree. What? They listed people that are not technically experts, and they anticipate that Bryan's team is going to argue that these people are not technically experts. Okay. The defendant takes issue with 22 of the disclosures, claiming they are insufficient. All 25 of the state's disclosures comply with the court's order and ICR 16b7 and are not the generic discovery response as presented in Morin. All 25 disclosures encompass more than a mere list of topics or general subject matter which an expert witness may testify. Each disclosure informs defendant of the main opinion to which each expert will testify and the CV which that opinion is based upon as required by this other case. For experts where the state does not have a report, if there is no data, the state doesn't have to produce data. The state addresses each objection to the proposed disclosures as follows. Okay, so what I'm getting from that is if the expert doesn't give data, then it's not, the state doesn't have to actually give a damn about there being any? Is that what that means? For Exhibit S1 and S6, the state disclosed expert opinions regarding the toxicology results for all decedents as detailed in the provided toxicology reports. Okay. I'm actually kind of glad they're talking about this. Okay, so Bloom, of course, is going around telling people that he got a hold of the toxicology reports and that they were clean. Doesn't really make a lot of sense if, Maddie and Kaylee were so drunk they couldn't stand on their 2 feet without being hella wobbly. That doesn't make sense whatsoever, but maybe he's just meaning there wasn't any hard drugs in their system and he's just not talking about the alcohol, even though he shouldn't be talking about the toxicology reports at all. But in reviewing him saying that again about a week or so ago, somebody did bring it back to my attention that in the very beginning we were told by the coroner, by Mabbitt, I believe it was, that toxicology wasn't something that they were even worried about. So the fact that it was done, protocol, it should always be done. But I did always find it strange that she said that, because why wouldn't you do toxicology? But what does the toxicology have to do with whatever they're talking about with Bryan? Unless it is being shown that they were just so drunk that they couldn't fight it off, which is going to be like their excuse for why one person was able to do this like a ninja in like 7 to 9 minutes. That's not going to work for me, but okay. In addition, the state included the toxicologist credentials, which supported his or her opinions. This disclosure was not merely a topic list of general subject matter, which the expert may testify as precluded in Morin. Instead, it is the main opinion and the credentials which support the opinion as required by coach, as I think how that's said. I don't want to say that word wrong. So, yeah. As noted by the whatever court, the Idaho rule is not as broad as the federal rule, which requires the basis and reasons for those opinions, whereas the Idaho rule requires the facts and data of those opinions. States S1 and S6 disclosure satisfy the requirements of Rule 16b7, meaning, what was it? That if there isn't any, the state doesn't have to produce any. Well, then why the hell is it being listed as part of the evidence if you don't have to produce anything? What kind of system is this? Who wrote these? Like, this is wild. For Exhibit S2, the state disclosed special agent balance. Disclosed what? Disclosed what? Just the fact that he's there? Going to be part of it? We know that already. Y'all left one of his signed documents on the public record. The state's disclosure was adequately specific. For examples, S2 states SA Balance will provide his opinion as to general locations in which the target cellular telephones were located at various times before and after the homicides of 1122 King Road and the cellular phone's directions of travel. So more than one, meaning most likely the victims too. Hey guys, I'm just jumping in for a second. Last night, after I recorded this full video, I was having conversations on Twitter about this part of this, so I just wanted to put this in here real quick before I uploaded it for you. Some people believe this is for Bryan's multiple phones. I don't disagree that there's multiple phone numbers. We've talked about there being a second phone number that's different whenever it comes to what's in the PCA that he had active at the time of the crime, and a phone number that was on the WSU directory for him right whenever his arrest was announced and everybody was scouting out his information. We also know that there was another phone warrant that was placed under seal pretty much as soon as Ann Taylor became his lawyer. It was one of the very first things that was done after he got back to Idaho. But this is my thing with that. If they had another phone that had location information that actually put him at the crime and not all this boo-boo that they've got in this PCA, they would have used it instead of allowing all of this insanity to happen with literally no evidence. And it's not also too unfathomable to believe that the victim's phone's information is also being tracked after the time of the crime. People do crazy shit with phones. Okay, look, some of you probably didn't see this, but right before Christmas, a friend of mine's grandfather was killed by her cousin. And he ended up trying to hide his body in the laundry room and then stole the car to flee the scene and left with the grandpa's phone. So when grandma got home and saw that her car was missing and called her husband to be like, hey, where did you and so-and-so go? He didn't answer. And when she was looking around the house for him, she didn't see him. She got a call back from what she thought was her husband's phone. But on the other end of the line was her grandson, admitting to her right then and there, as soon as she answered the phone and said, where are you guys at? He just admitted and word vomited how he had killed grandpa and hid the body in the laundry room. Okay, this was just a few weeks ago, right before Christmas. So for a phone of a victim to be looked at after the time that they're no longer alive, that's not abnormal. It's really not. So is this Bryan's phones in the victim's phones? Probably, because they have to look at everything, but I don't know. It could be about the other phone number, but I don't know what they could possibly be saying about it. They have nothing about it in the PCA. They're not claiming that this other phone put him anywhere. They're not claiming anything about the other phone. Everything they're using is the AT&T phone. But we will do a video, smaller video, when it comes to the phones, just to get that information clarified and out there. I just wanted to put this in here for now. The attached report detailed the target cellular phones analyzed, the dates analyzed, and the direction of travel. In addition, defense was directed to the cell phone records provided by AT&T and the drive testing files which support the report. The defendant appears to be requiring compliance with the federal standard, which is much broader than ICR 16b7. The state's disclosure provides defendant with adequate notice of Balance's anticipated testimony to satisfy the requirements of ICR 16b7. For Exhibit S3 and S4, defendant correctly agrees these disclosures meet the ICR 16b7 requirements. For Exhibits S5 and 7, the state disclosed two likely fact witnesses as experts out of the abundance of caution and was clear about this intent. What is a likely fact witness? The defendant argument that the state erred in this good faith disclosure is without merit. In the event either of these witnesses are in fact experts within the meaning of ICR 16b7, it is clear from each disclosure exactly what these witnesses will testify to based upon the provided disclosures. What? In the event these witnesses are in fact experts? So do they have knowledge of something that's important to the case and have some sort of backing in it, or what? Because we already had people that do IgG stuff that there's no degree for, no credentials for. Like, you basically have to get into it and get dirty in order to learn it. Okay. Junk science versus junk science. Technically, you're an expert in it because you've taught yourself and you've done the work yourself and you know how to do it. You've gotten results. But is that can't be what they mean by this. Likely fact witnesses that might be experts. That is honestly, I'm not going to pretend like I know anything about what I just read. What the hell does all of that even mean? A fact witness provides testimony based on firsthand experience. They offer a factual account of what they observed or heard without interpretations or opinions. Role, share factual information without subjective analysis. Okay, but what's the difference between that and a regular witness? Fact witness. Example, a fact witness in a car accident case could be a pedestrian who saw the collision or a passenger who experienced it. So then what's the difference between that and a lay witness? A neighbor who heard a loud crash and describes what they observed. So what's the difference between a pedestrian seeing the collision or a neighbor who heard the loud crash? I don't see a difference here. In the event either of these witnesses are in fact experts. I just don't understand what the hell that's even trying to say. For Exhibit S-8, the state disclosed the vehicle identification expert SAML. The disclosure specifies he will testify to his use of forensic audio, video, and image analysis program. The forensic audio, video, and image analysis program was used to determine the make, model, and year of a suspected vehicle involved in the 1122 King Road burglary and homicides in Moscow, Idaho on or about 11/13/2022. It is clear from the disclosure that this witness is an expert in vehicle identification. Defendant has repeatedly been provided the images relied upon, which are detailed in his report of examination, which was attached to the state's disclosure. The state's disclosure provides defendant with adequate notice of special agent emails, anticipated testimony to satisfy the requirements of ICR 16b7. So it has the detail report. I wonder if it has the dates on whenever he changed the vehicle year, because we didn't know that it was moved until the PCA, if I can remember correctly, which all that's going to end up going on my timeline because I'm just so tired of them trying to get away with bullshit. I should have been working on this timeline this entire time, and I sort of do have timeline stuff already put together, but there was 2 of them on a Word document, 2 separate Word documents, and then I have binders that have stuff written down in it, and then I have notebooks full of stuff. I'm trying to get everything combined together. Exhibit S9, the state disclosed Kathy Mabbutt, the Latell County coroner. The state specially detailed each opinion to be proffered. The opinions were supported by the attached death certificates authored by the coroner and the coroner's credentials. The defendant fails to mention that in addition to being an attorney and an elected coroner, Ms. Mabbutt was a registered nurse for 44 years, which is detailed in her credentialing. The state's expert disclosure satisfies the requirement of ICR 16b7. Okay, but if she was a coroner, that's already the only part of her credentialing that really matters. I mean, I get her being a registered nurse for 44 years shows that she has medical experience when it comes to knowing about the body. But if you're a coroner, it should just be expected that you know what the hell you're talking about anyway. For Exhibit S10, 13, and 14, the state disclosed forensic detectives. These disclosures specifically listed each forensic team to which the witnesses would testify regarding. The witnesses' expertise is the process of extracting and identifying the data that is on each of the listed devices. The contents of each of these devices have been disclosed to the defendant. Okay, but there's nothing there according to the defense. There's nothing in any of that states anything was actually found or what's going to be presented as actual evidence against Bryan Kohberger. Any opinion related to that extraction, i.e. whether a connection was found or not, is not an expert opinion. As a result, the disclosure meets the requirements. So they're admitting that there's nothing there because what they're considering an expert opinion doesn't fall into what the defense is actually looking for, which is proof that there was a connection between the victims and Bryan. Because so far, what has been the story? That there's not. So the state is trying to make an excuse for the reason why they don't have any of that information in there. Well, but that's because it's not an expert opinion. But aren't you supposed to submit your discovery? What's the difference here? That, man, they are just dancing and dancing and dancing. Their feet about to be hurting. For Exhibit S11, defendant correctly agrees this disclosure meets the requirements of ICR 16b7. For Exhibit S12, the state disclosed an expert on crime scene reconstruction and blood stain pattern analysis. They hired Dexter. The state specially detailed each opinion to be proffered. The opinions were supported by attached referenced report and credentials. The state's disclosures provides defendant with adequate notice of this expert's anticipated testimony to satisfy the requirements of ICR 16. As noted in that other case that I don't want to mispronounce, the defendant has identified areas through the disclosures for cross-examination, which only evidences the adequacy of the disclosure. So basically, he's saying that the defense has already outlined and has already decided what they plan to use on cross-examination, which is basically the defense stating everything you gave us for this one meets the rules, so we don't really have an argument with it. So I guess, okay, whatever. Next. Exhibits S15 through S25 all relate to the Idaho State Police Forensic Lab experts. First, the defendant claims not a single DNA expert opinion or report was produced. This is simply not true. In each of these responses, the state refers the defendant to specific lab reports and the corresponding Bates numbers. The defendant's apparent argument that the state is required to make duplicative disclosures is unsupported. Is that what they're claiming? I don't think that's what they're claiming. Maybe it is because they're all the same. Like they all come from the same forensic lab. Maybe that's why they're saying that. A simple reference to where defendant can find the report is adequate. So there's no actual report. Okay, so they're basically doing it the way that they've been fighting all this stuff from the very, very beginning, stating that this argument is going to be in the AT&T one and in the Google one and in the Pin Trap and Trace one and in the Lambsden address one and blah, blah, blah. So we're only going to put it in this one instead of putting it in here 5 separate times. They're basically just trying to keep the theme. Each report provides a basis to determine what the expert's opinion is through the referenced lab report. As an example, the state is attaching Bates 93239354 for the court's review for how these disclosures comply with the requirements of ICR 16b7. See Exhibit S1 attached. The state follows suit in disclosures S16 through S20 and S22 through S25. The state's expert disclosures regarding lab experts satisfy the requirements. For S21, the state disclosed Rylene Nolan as an expert. We've heard that name before. It is anticipated that this witness is actually a rebuttal witness who is prepared to testify regarding secondary transfer if necessary. That's important. Prepared to testify regarding secondary transfer if necessary. Oh, I think it's going to be. The state contends the notice provided is sufficient pursuant to the rule, but reserves the right to amend this disclosure upon review of the defendant's guilt phase experts and pending discovery disclosures. As required by Rule 16J, the state will continue to supplement the response if the state later discovers or decides to use additional evidence. Lastly, if the court determines that any of the disclosed expert disclosures do not meet the requirements of Rule 16b7b, the state will promptly amend. Any contention that the defendant has been prejudiced or does not have adequate time to respond is wholly unsupported. The defendant's request for sanctions is premature and without merit. Conclusion. The state respectfully requests that the court deny defendant's motion to compel ICR 16b7 material and for sanction. Based upon the filings in the case, pursuant to 4th Judicial District Rule 5.3, the state is not requesting a hearing on this matter. That's because I feel like with Hippler being a stickler, he's probably going to be like, cough it up. I feel like. But I also find it interesting that all of these things were sealed and then just all of a sudden the state just word vomited pretty much all of their expert witnesses, even though the list itself is sealed. And of course, we have the normal formatting that they always respond to when it comes to the supplemental request for discovery, where they claim we're doing what we're supposed to do. Now let's go ahead and get to this subpoena. Okay, this is the one that I posted in my community tab that I'm talking about at the beginning of this video. The one that we talked about previously was the subpoena ducis tecum, which is the one for expert witnesses. I know for a fact that this one is for regular old schmegulars. You know why? Because whenever they try to subpoena me the day before court with my DV situation, I had this exact same verbiage, except mine was a $500 fine. Okay, this is for a normal ass person, which it's probably those maybe experts who might be experts one day, the ones that makes no sense whatsoever. But this is for also 2 days. This isn't just for one day. It says here, you are hereby commanded that, laying aside all excuses, you appear in the District Court of the 4th Judicial District of the State of Idaho in and for the County of Ada in Boise, Idaho, on January 23rd, 2025 and January 24th, 2025 at 8 a.m. We only know of one day. So did they extend it and we just don't have an updated order, or what's happening with that? And it just says, as a witness in the above entitled matter, and then threatens them with the fine if they don't show up. And see, the other one, the subpoena ducis tecum, was basically like, you don't have to show up if you give me all of your reports. Like, come and drop off everything that you should have already handed us, and then you don't have to show up in court. This one doesn't have that. This is a person. And also, this was put out by Ann Taylor, because it's not stating to call Bill Thompson's office or to call Ashley Jennings or to call any of them. It says, please call Ann Taylor Law, PLLC, at here's the number. Yeah, so this is being issued by the defense team. Now, the state filed something about Detective Mowry, and they ended up having to do an amended expert disclosure, so I'm wondering what ended up having to be corrected. And the defense is asking for more time to give them their guilt phase experts. Now, this case has been going on for a while. You know what's coming. All of this deadline stuff I find absolutely ridiculous, because there's a pattern to these things. You know what's expected, right? I'm just going to put that out there. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby moves this honorable court for an order to extend time to disclose defendants' guilt phase experts. The court's October 9th, 2024 scheduling order established expert disclosure deadlines. The state's guilt phase experts were timely disclosed on December 18th, 2024. After reviewing the state's disclosure, Mr. Kohberger filed his motion to compel ICR 16b7 material and sanctions on December 27th of 2024. Mr. Kohberger's motion to compel cannot be heard by the court until January 23rd of 2025, which is the deadline for disclosing defendants' guilt phase experts. Until the state makes proper disclosures and the court issues a decision on Mr. Kohberger's motion, the defense cannot adequately respond to the opinions offered by the state's experts. Thus, Mr. Kohberger respectfully requests that the deadline for defendants' guilt phase experts be extended past January 23rd, 2025. The suggested deadline is 30 days after the state properly discloses expert opinions, or at a reasonable time after the court hears the motions and issues a decision. Now, I understand that the state's disclosures are lacking, but from everything that they already know that's going on with this case, all of the things that they already know that are at play, way more than we know about what's at play here, they pretty much know the type of expert witnesses they need for this case. They should have the majority of this already handled so that they only have to deal with the leftovers, if that makes any sense. Like, they should have their own DNA guy. They have Cyray. He's their cell phone guy, their location guy. Like, they should have all of this already. So I'm just saying, I feel like we just need to get to trial already, because this is getting stupid. Now, we do have the defense's reply to that long 11-page objection by the state that we just read. It's only 5 pages. Let's go ahead and go over it. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby replies to the state's objection to defendant's motion to compel ICR 16b7 material and sanctions. Mr. Kohberger is protected under the constitutions of the United States and the state of Idaho to a right to a fair trial, to confront his accusers, the presumption of innocence, and effective assistance of counsel. In effort to protect his rights, the Idaho Supreme Court has pronounced rules governing criminal discovery through Idaho criminal rules. Mr. Kohberger asserts the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. I don't understand how the state can say, well, that's not an expert opinion, so it doesn't really matter what they found. The rules say we don't have to turn it over. I just feel like it's because you really just don't have anything. I think the defense is right. There's really just nothing there. Mr. Kohberger cannot fairly confront the evidence the state intends to bring against him when he does not know what it is. But again, for the most part, bro, you kind of do. You kind of do. His counsel cannot be adequately prepared to represent him at trial, given the state's lack of adequate expert disclosures. Failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about, or leaving open-ended opinions, in essence, shifts the burden to Mr. Kohberger. I mean, yeah, and in the end, it's on the state to prove that you are guilty. You're not supposed to have to prove your innocence, even though it helps to do so. Okay, you're not supposed to have to. The state is the one that has to prove their case. And with them having nothing, but Bryan still having to fight his innocence, it does put all the burden on the defense. They're not wrong. He is forced to respond to unknown expert opinions with unspecific scientific, technical, or specialized knowledge while giving the state the ability to disclose its further or actual expert opinions in rebuttal filing on February 13th, 2025. This failure to disclose expert opinions not only prevents Mr. Kohberger from confronting evidence against him, but also prevents him from assessing his need to file motions in limine and motions to exclude expert witnesses who do not meet Idaho's evidentiary standard, which is what the state meant by they expect the defense to argue they're like not really expert witnesses. That whole thing is just still weird. Otherwise known as Duvall-Frye hearing. Deadlines are looming. This motion cannot be heard until January 23rd, 2025, the actual defense deadline. Motions in limine are due February 10th, 2025. A motion to extend time to file some is filed simultaneously. Argument. The court has the state's sealed exhibits S1 through S25. The state's filing consists of over 400 pages, mostly credentials of the named witnesses, and very few details of expert opinions with a few exceptions. Yeah, when they have somebody's information attached, it can go on for pages and pages and pages and pages and pages of just things that these people have done with their lives. It's like where they graduated from, where they've given a talk at, if they've been published anywhere. It's usually a lot. Approximately 2,000 pages of discovery are referenced in the DNA exposures. The court does not have the discovery pages in the expert disclosures, but for one example attached to the state's objection as S1. Most of the disclosures have catch-all phrases that the expert will rely on the work of unnamed others. That the disclosure is meant to be an aid, we read that part, but does not encompass all finding, impression, conclusions, or materials related to this expert's involvement in this case, or that the disclosure does not in any whatever, parentheses, limit the scope of the expert's testimony. See, this is exactly what we heard about Payne and the way that the PCA was apparently written, which y'all know I'm doing that big comparison video. I honestly, at this point, still cannot tell if Blaker's was first or if Payne's was first, because there's stuff in Payne's that looks like he did copy and paste it out of Blaker's and just put it in there incorrectly, but then there's certain verbiage in Payne's that makes it sound as if his was really the one that was written first. But then I question why that one from Payne wasn't the one used in Washington for Bryan's apartment and office search. It's just all very strange. But I'm bringing that up because we already heard from Payne on the stand. And the way that he described how he did everything was that he went and had conversations with people that had actual knowledge of these certain topics, and then basically went back to his desk and played telephone. He took whatever he was told and then tried to put it into words. If you are an uneducated person listening to a very, very, very specific topic, but you have no education in it whatsoever, you can't come back out here and repeat what you heard and get it right. That's not how this works. The human brain is incapable of doing that kind of thing. You really just cannot continue to fake it till you make it. Eventually, you break it. And this sounds exactly the same, that they're going to be coming, certain people, certain expert witnesses are going to be coming into the courtroom to testify somebody else's experience, somebody else's opinion, somebody else's analysis, somebody else's work. How is that even allowed? That is so stupid. The language essentially places no limits on the testimony of the expert and places Mr. Kohberger at a disadvantage because he cannot prepare for the unknown opinion of an expert that would be proffered for the first time on the witness stand in front of a jury. The state disclosures violate his constitutional rights under the 6th Amendment and 14th Amendments to confront and cross-examine the witnesses, confront the evidence that the state intends to present, and his counsel's ability to effectively prepare. Some of the expert disclosures are extremely broad and encompass topics that are not touched upon in any reports or discovery provided. These disclosures do not allow Mr. Kohberger to evaluate the scope of the opinion, assess how his own expert witness will need to respond with countering opinions, prepare to confront the evidence the state intends to elicit, allow counsel to competently prepare for trial, and determine if a motion in limine or motion to exclude will be needed. Other disclosures contain lists of areas of testimony without more. Mr. Kohberger is provided no clues about the expert opinions on discovery disclosures that are vast, hundreds of thousands of pages. Attached as Exhibit B under seal is a more detailed argument related to the lack of disclosure for specific experts. The state's objection to defendant's motion to compel ICR 16b7 acknowledges its duty under the rules. The quantity of 68 terabytes of discovery, we have a footnote, as a point of reference, a single terabyte is the equivalent of 75 million pages of text. And then it gives, let's see where this takes me. Of course, it never works. None of these ever work. Oh, you know what? Speaking of links that are weird, For some random reason, and I didn't want to make this a video in itself because that's weird, but for some random reason, one of Forensic Frenzy's videos popped up on my feed, even though I told YouTube like a year ago not to recommend that channel to me. So for clicks and giggles, I went over there and clicked on it and saw that she had a website. Like it's literally like forensicfrenzy.com. So I clicked on it and look what happened. So whatever website that she has up there, it's literally something that's trying to steal people's information. That only popped up because I use a VPN. So do with that what you will, but I never trusted that woman. And the disarray to which the state has both received and produced the discovery. Completely a mess, discombobulated. The state interprets the motion to compel as one of complaint that adequate information has not been provided. And again, see the footnote on page 2. Mr. Kohberger's argument is that given the overwhelming amount of discovery in this capital murder case, compliance with discovery rules related to expert opinions is vital to be informed of expert opinions being offered against him. Mr. Kohberger's experts need to know exactly what opinions and supporting materials each of them is confronting in this case, as well as allowing competent representation by counsel. He needs to know what scientific, technical, or specialized knowledge the witness holds to qualify him or her as an expert. The discovery rules are designed to safeguard the truth-seeking functions of trials, promote fairness, and/or to facilitate fair and expedited pretrial fact-gathering and to prevent surprise at trial. The expert witnesses the state discloses are all relying on underlying data and technical or specialized knowledge, but what they intend to testify about using such knowledge is unknown. And there's a big footnote. The state submitted exhibits S-1 to its objection as an example of discovery that qualifies as an expert report. That was mentioned in that 11-page one from the state that we just read, but of course we didn't get to see it. This exhibit is a list of items collected. If the witness associated with this list is simply a chain of custody witness, an opinion is not necessary. If the witness will testify that evidence was collected in accordance with her training, proper procedure, and lab protocols, that calls for and qualifies as her opinion. If this witness testifies that others gathered evidence in accordance with proper procedure and protocols, that also qualifies as an opinion. The lab protocols and evidence collection procedures have not been disclosed. If the state wishes to elicit her opinion regarding whether or not evidence was collected in accordance with her training and lab protocols, that is an opinion. If the state wishes to elicit any results of the test and what they mean, that is an opinion. This is a good example of how the state's disclosures related to DNA are lacking in this case. Yeah. No joke. How do they just not have anything? Like, come on. Conclusion. Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting. The expert evidence disclosed by the state is inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd of 2025, and it's written by Masoth. She usually does a pretty good job putting stuff together. So what I've basically gotten from these documents is that the state has no issue going against whatever the gag order considers needing to be sealed, because they filed the sealed expert witness list, but then basically told us more than half of the people that are going to be their expert witnesses. Okay, that's number one. Number two, they've got somebody coming in that's technically not an expert, but that could be an expert, and they're prepared for the defendant to argue that they're not experts. That is like hella confusing. And I can't even say that that's what the other subpoena is for, because that subpoena, both of these subpoenas, the regular one with the fine and the subpoena ducis tecum, are both being filed and issued by the defense. So I don't know. I really am still thinking that the one for the expert witness that the defense filed is most likely the DNA expert, because they've been claiming from the beginning that they were going to use the state's evidence in order to prove Bryan was innocent, in order to exonerate Bryan. So if they're going to keep the theme, then they would have to call in people from the state's list. That's the only way that makes sense. But I really want to know who this other subpoena is for, because there's 2 dates on that person's subpoena, not one. Not just the 23rd, but the 24th also.
And the state is basically acknowledging all of the missing information, but they're using excuses. Well, this isn't considered an expert opinion, so it doesn't matter that nothing else is there. Excuse me? Excuse me? You have to prove your case. You can't just go in front of the court, in front of a jury, in a murder trial where the man is going to be sentenced to death, most likely, if he's found guilty, and not have anything to produce and expect it to go your way, sir. So I don't understand what's the point in all of this. If they're basically saying, yeah, we have nothing and it's fine because this rule says we don't have to have it, how is this the law? How is this even allowed? How did we get this far? But other than that, all I've got to say is it's a good thing I used the crockpot today because I'm going to be sitting here for a while in order to get this video out. But I want to know what you guys think about everything that we just read in these documents. And also be careful going and clicking links, because people be shady. But that is it for now. Let me know what you guys think about everything down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you were not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.